Yes,
my Lord, I'm due to shut up and sit down in 10 minutes. I am probably going to go a bit over that and take it out of my time. Now, my Lords, I said to your Lordships this morning, and it is true, and I don't think anybody suggests otherwise, that the Mackay principle has not been cited or relied upon or applied in any previous English case. Now, as was pointed out to me, one reason for that is it wasn't actually formulated as such in the way it is in any previous case prior to this one. That in itself, I submit, is not insignificant. But more than that, there is no previous English case setting aside a batcher which in terms purports to apply any principle to the effect that the debtor's breach makes a conditional debt unconditional. I say aside from a batcher. Now, two things to note about a batcher. First, a batcher was a straightforward case in which there was a claim for breach of contract sounding in damages equivalent to what the debt would have been. It's all about interest for late payment. And also about a batcher that Lord Justice Ricks himself was clearly inclined to think that it was a Dominique Caron-Vatis debitum in praesentum sort of case. He suggested that to the parties in argument. He didn't pursue it because they obviously hadn't been ready to argue it. But it's not a necessary explanation for a batcher, but in any event, a batcher is the only case prior to this in England which purports to apply any principle along the lines that debtor's breach makes conditional debt unconditional. And that, I submit, is quite striking in circumstances where the Court of Appeal's analysis, paragraph 77, is that the Mackay principle, as ultimately formulated by the Court of Appeal, at least reflects, if does not repeat, a consistent body of case law from at least Hotham against East India in 1787, and possibly before that. And I do submit that if the principle has in some way, shape or form existed for that long, it is legitimate to ask what is the, as it were, the index case, what doctors would call patient zero. Where is the case in which it's formulated as a proposition by counsel? It's debated on its merits in counsel's argument. It's considered on its merits by the court as a matter of authority, if there is one, as a matter of principle to the extent there is no authority, and the court says in terms, this is English law, and we're going to accept this as English law. And the answer is that there just is no such case. Certainly not Hotham. I'd hoped to go to Hotham and some of my learned friends' cases today, but given where time is, I think I may let him open them and come back to them tomorrow. But what I'll say about Hotham is this. It is a one-page, less than one-page judgment. It's perfunctory, and it is inconceivable in my submission that Mr. Justice Ashurst thought that he was welcoming any new principle into English law in circumstances where his judgment treats it so very, very briefly. And it's perfectly plain in my submission that Mr. Justice Ashurst understood himself to be applying settled principles of English law, and what they were I will come on to in a moment, but they were not the Mackay principle. And ditto in Panamida. The relevant part of Lord Thankerton's speech in Panamida, again, is about a page. Most of Lord Thankerton's speech is taken up with a review of Mr. Justice Atkinson's findings of fact. What he says about this point is incredibly brief. And again, in my submission, it is simply inconsistent with any suggestion that Lord Thankerton understood himself to be embracing any new principle of law. And again, he relies upon and he cites very venerable authorities. They are not authority for the Mackay principle. What they are authority for, I'll come on to in a minute. And the short answer in my submission to what is the index case, and the only possible answer to what is the index case, is this one, as a matter of English law. One of the points about a batcher, it's picked up by Mrs. Justice Dyers at first instance, is Lord Justice Ricks didn't really grapple with, or didn't even really seem to notice, that Mackay and Dick is actually a Scottish case, so he didn't really attach much attention to that.
Well, curiously, it's a Scottish case argued by very distinguished English counsel.
They brought in English counsel to try to wrestle it back at the last minute, and he just complained about his junior's pleadings in the time-honoured fashion, but didn't really get him very far. But your Lordship is right. They did get eminent counsel of the day. And on one aspect of it, decided by one of the most eminent of English judges, but in a way rather different from Lord Watson. Now, my Lord, because your Lordship knows, Lord Watson's, which is some sort of theory of deemed fulfilment, Lord Watson's analysis is based purely on two sentences from Bell's principles. And whatever one may say about them, they are plainly radically different in form from what the CO Court of Appeal had to say what the principle was in this case. Now,
when you say there's no previous case that's accepted the principle, you mean the way in which it was formulated by Lord Justice Popplewell?
Or
clearly you might say that your opponent can draw on quite a lot of statements about parties in breach not being able to rely on a condition that they brought about themselves. You know, it may not have been formulated in quite the way that Lord Justice Popplewell has, but are you going further than that?
there is no case, my Lord, this is my submission, there is no case in English law, apart from a Batcha, in which any principle to the effect that the debtor's breach makes a conditional debt unconditional has been applied, and a conditional debt has been to be held unconditional on the basis of such principle. Now, your Lordship anticipates, my learned friend says there are cases which are, and he's going to come to them, and as I say, given the time, I'm probably going to come back to them tomorrow. But that is my submission. Those cases are not concerned with any such principle. Now, your Lordships, we've mentioned in our case...
I suppose I'd say that certainly there's no deemed performance acceptance of the deemed performance analysis, but I'd be surprised if there's no support at all for something along those lines. But anyway, I won't delay you anymore.
I'm grateful. I will come to my learned friend's cases. Now, my Lord, we set out at paragraph 136 and following of our written case, the process, the analytical process by which the Court of Appeal came to the conclusion that even if it was not expressly stated in any previous case, there was to be detected in the previous case law a principle to the effect that the debtor's breach makes a conditional debt unconditional, and which supported the principle which they ultimately formulated in paragraph 85. And as we set out in the case, we submit that you can see, if you follow it through, that what happens is that the Court of Appeal saw in these cases, and this perhaps goes back to my Lord Justice Burroughs' interjection a few moments about statements in the cases. The Court of Appeal saw in some previous cases some fairly high-level comments along the lines of party not entitled to take advantage of its own wrong.
Sorry, I didn't hear you.
Because party not entitled to take advantage of its own wrong, my Lord, that's a phrase which gets bandied around in the Court of Appeal, and it's certainly mentioned in some previous cases. Phrases such as, cannot rely on one's own breach, prevention excuses performance, and the Court of Appeal deduced from those the principle which it set out. And in my submission, those materials do not support the proposition which the Court of Appeal deduced. That then leads to the question, well, what do they say? And that's what I wanted to spend a few minutes on before I sit down, is just to go through what in our submission the English law setting a Batcha aside was prior to the Court of Appeal decision in this case, and in particular what is being referred to in some of the material which is cited in old cases like Hotham and also in the Panamina case, cases which are fundamental to my learned friend's argument. Now, we have set this out in some detail in paragraphs 34 to 71 of our case, at pages 26 and following of the bundle. And I don't detect that from my learned friend's case that they really take any serious issue with anything we say there. And that being so, I'm hopefully going to be able to take it fairly quickly in a bit under 10 minutes. And I just want to highlight a few points and make a few comparisons and contrasts with what is now said to be the Mackay principle. Now, the starting point is that there is a very old principle of English law, that if D is to make a forfeiture to P unless D performs a condition, whether it's a forfeiture of a debt, damages, the loss of freehold land, the termination of leasehold, the loss of a contract, whatever the nature of the forfeiture, P cannot enforce the forfeiture if P prevents D from performing the condition. And we have explained that in our case at 34 to 46, page 26 and following of the bundle. And that is the old law of the medieval penal bond, where the debtor is under an obligation to make a payment in debt unless a condition precedent, forgive me, a condition defeasant is satisfied to defeat the debt obligation. And it's the way that medieval law deals with contracts and bargains in a time before there's any really developed law of contract. If P wants D to build a house, then what happens is that D executes a bond by which D undertakes to pay £200, and it's subject to a condition defeasant that if D builds the house, the debt doesn't have to be paid. And P agrees to pay £100, and P enters into a bond, and P's bond is to pay £200, and that's subject to a condition defeasant that if D builds the house and P pays the £100, then he doesn't have to pay the £200. Now, in form, what you it's a bit like Roman stipulatio. In form, what you have are two independent documents, deeds, and each of which only contains an undertaking by one party, and the only undertaking is to pay money. The defendant doesn't promise to build the house. He's not under any contractual obligation to build the house. He just promises that unless he builds the house, he'll pay £200. That's his only obligation. But if you draft these things sufficiently carefully and you exchange bonds reciprocally so that one of them reflects the building of the house and one of them reflects the price, you can use these things to do absolutely everything you want with a law of contract. They're incredibly flexible. And one principle, which is very clear from a very early stage, is that if P, for whom the house is to be built, changes his mind and says, I don't want the house, I'd rather have the £200, and he shuts the defendant of his land so that the defendant cannot build the house, P cannot then say, the condition has not been satisfied, I will take the £200, please. Now, the condition has not been satisfied. But the law is very, very clear. You cannot prevent performance of the condition and then say you want the money. You cannot do it. And the language which is used is that the obligation is discharged or excused. Now, I'd make a number of points about that. First, it is a principle of prevention. What engages it is that the creditor, the obligee, prevents the debtor from performing the condition defeasant, or interferes with the performance of the condition defeasant. It is a prevention principle. The second point about it, it has got nothing to do with breach of contract. The prevention by the obligee, by P, does not have to be a breach, and in fact it won't be a breach, because the only obligation which P undertakes is the obligation under his own bond, and the only obligation he undertakes is to pay money. I mean, again, it's a bit like the stipulatio. The only obligation you undertake is what you say. There is no room to imply in a bond, which is a bond to pay money, an obligation that you will not interfere with the performance of the condition defeasant under somebody else's bond. So it is factual prevention, it's not based on breach of contract. There isn't, in our modern sense, there is no contract in which you can imply a term. There's merely an exchange of bonds containing obligations to pay money and no more obligation than that. Thirdly, as what I said I think will make clear, it is a defensive principle. It protects the debtor who has been prevented from performing the condition defeasant from the obligation to pay the debt. In the case I've given of the house building, if P bars D from the land so that D cannot build the house, P cannot claim the £200 under D's bond. It's defensive. There's no suggestion that means that D can recover under P's bond either the £100, the price for building the house, or the £200 penalty. It's a purely defensive. And I just ask your Lordship to note, they've made 3 points there about it, that the contrasts with the Mackay principle. The bond rule turns upon prevention. There is no requirement for breach. The Mackay principle, as I said this morning, breach by the obligor or by the debtor is the essence. That's what triggers it. And the bond principle, as I just said, is a purely defensive principle. The Mackay principle is an offensive weapon. It gives you a cause of action in debt, notwithstanding that on the face of the contract, the conditions precedent to your acquiring that cause of action in debt have not been satisfied. Now, the old principle does not give you a cause of action, purely defensive. The fourth point, just ask your Lordship to note about the bond principle, is this. The condition which D, the debtor, had to satisfy the condition defeasant in order to get out the debt obligation, it did not have to be a promissory condition. Not only did it not have to be a promissory condition, by definition it wouldn't be a promissory condition because, again, the only promise which you make under your bond is to pay money. And again, as I said, D, in the example I've given, he doesn't promise to build the house. He's not under an obligation to build the house. He's just building the house as a way of escaping his debt obligation. He's not bound to do it. And I ask your Lordship to remember that in the context of Hotham, Panamina and Corey, in all of which what the service provider was trying to do was to obtain a certificate. And one of the points that's made by my learned friends is, well, that's got nothing to do with this old prevention principle because they weren't under any obligation to obtain the certificate. It wasn't part of the performance. Now, that is true in those cases, but equally in the medieval law, it was never part of the rule that the condition which you were prevented from performing had to be a promissory condition. It didn't. So that's the principle which originates in the medieval law of bonds. That is the law which is cited and set out in Rolls Abridgment and Common's Digest. Now, the Court of Appeal thought that the Mackay principle could be traced back to Rolls Abridgment via the Hotham case, because the Hotham case cited Roll, and back to Common's Digest via Roberts and Bury, because Roberts and Bury cited Rolls Abridgment. That is a misunderstanding of what Roll and Common are talking about. They are talking about the medieval prevention principle, which is an offensive principle, not based upon breach. Now, just for your Lordship's note, we have given you Rolls Abridgment at page 125. Forgive me, tab 125. The principal passage in it is section N at page 1640. As well as being in an incredibly unreadable Gothic typescript, it is written in Law French. It is translated by Viner's Abridgment. Viner's Abridgment is a translation of Roll with extra cases added by Viner, and your Lordships have that at tab 129, and section N is at 1693. 1693, my Lord. Now, for your Lordship's notes, there are, I think, about 28 cases given by way of illustration in Viner. 1 to 14 are the original from Roll, and the rest are additions by Viner. Now, my Lords, over time, that principle spread from bonds to covenants, and we've given some examples in our case at 41, including some examples from Cook on Littleton, which are referred to by the Court of Appeal. Cook on Littleton, again, is referring to the same defensive medieval principle. In time, covenant-like debt on a bond comes to be superseded by the modern law of bilateral contracts based upon a sumpsit. And the old principle comes into modern law by way of the modern prevention principle, as stated in modern law by Home and Guppy. The familiar building contract case in which the builder is liable to liquidated damages if they don't complete by a certain date, and the employer cannot claim the liquidated damages if the employer prevents the builder from performing by the date. And my Lord, the point to note is that although the context in Home and Guppy has moved from penal bonds to bilateral contacts, the content of the principle is the same. The essence of it is prevention, not breach. The act of prevention does not have to be breach. Dodd and Churton in the Court of Appeal is clear authority. The prevention does not have to be breach. There are shipping cases, such as the Alters. We've given you, the Lordships, a reference to Scotland on charter parties for this. It has to be prevention, it doesn't have to be breach. And it's still a defensive principle. The effect of it in Home and Guppy is that the employer cannot claim to forfeit the damages. It's not an offensive weapon which gives you a new cause of action. Superficially, Home and Guppy itself may look like a case in which the prevention principle is used offensively to give the obligee a claim in debt. Because what happened in Home and Guppy is that the employer relied upon a clause in the contract to set off the supposed liquidated damages from the final balance of account. And that had the slightly quirky effect that the builder, which is the person supposedly in breach by not building on time, is the one actually suing. And the effect of the decision was the prevention principle barred the employer from seeking to forfeit liquidated damages. There was therefore nothing to set off, and therefore the claim for the balance of the price succeeded. But the reason that the balance of the price was due was not the prevention principle. That prevented the set-off. The reason it was due was that the builder had done the work. Now that does mean that analytically you can look at Home and Guppy perhaps in either of two ways. One is you can say that the employer prevented the builder from performing a promissory condition and claimed a right to forfeit liquidated damages for breach. The alternative way of looking at it is the employer prevented the builder from performing a condition to claiming the full price for the completed work, because it said it was entitled to settle. And it claimed a right to forfeit part of the price or part of the work or part of its value. Now, it makes no substantive difference which way you look at it. The effect is entirely the same. But I ask your lordships to bear that in mind in relation again to Hotham, to Panamina and to Corey, to which, as I say, I will come tomorrow. Now, my lord, your lordship knows there are procedural points in relation to what we have called the Griffon point and the Dominique point as to whether it's open to the respective parties to rely upon them in this court. And Mr. Barnard has kindly agreed to speak relatively briefly to those points. So subject to your lordship, I will belatedly shut up and I will sit down.
Yes, thank you, Mr. Eaton. Mr. Barnard.
My Lords, I will begin with the two procedural points relating to the parties' alternative cases.
I should say, I'm sorry to interrupt, but just so there's no doubt about it, clearly you're eating into your reply time.
My lord, I'm very conscious of that.
Yes,
You'll need to be near a microphone.
Give me my Lords. Yes, as a result of the time, I'll take these points relatively quickly. Let me deal with the buyer's alternative case first, if I may. As my learned friend Mr. Eaton said, we've called that point the Griffon issue, and in very broad summary, although my learned friend Mr. Eaton will deal with it in greater detail tomorrow, I'm sure, the fundamental issue is whether the Court of Appeal's decision in the Griffon was correct or not, and that affects, or the result of that decision, if the buyers are right that that decision was wrongly decided, is that the deposits were not forfeit. And so, if that is the case, the seller's claim is in damages and damages only, even if the sellers are right on the Mackay principle. Now, my Lords, you'll be aware that the sellers have objected to the court's jurisdiction, and indeed permission was granted by the court subject to the seller's point on jurisdiction. And essentially, the sellers make 2 points. They say, first, that the Griffon was not within the question of law upon which permission to appeal was granted. And secondly, they say it was not a point before the arbitrators for determination. I have 3 points to make. My first point is rather obvious submission that the issue as to the Griffin was indeed and is indeed within the scope of the question of law. And how I propose to deal with that is to show your lordships the question of law and to make some very brief points about it. Your lordships will find it on page 228 of the bundle. That is the buyer's arbitration claim form. You can see it as item 4 towards the bottom of the page. Now, the first point I ask your lordships to note about the question of law, it's very obvious from the third word, or the second and third words, it's put in the abstract. So it refers to an obligation for payment within a contract. I'll come back to that in a minute. The main point I ask your lordships to take note of is the fact that the question is not simply focused, and is not so narrowly focused, as the sellers would suggest, on conditions precedent. It also, and crucially, asks the question, what remedy do the sellers have, and what claim do the sellers have? Your lordships can see that by the third line, the reference in the third line to the words, with the result. Is the result of the condition precedent being fulfilled, if that is the result of that the payment sum can be claimed by the sellers in debt? That is the other party in the facts of this case. Or must their claim be in damages? So, my lords, my submission is that the question of law does include the question of whether the result of the fulfilment of the condition precedent, if that is what is if that is the answer to the Mackay principle, whether that results in the sellers having a claim in debt or not. And in my submission, that includes, therefore, the question whether the Griffin was rightly decided or not. And I submit that the sellers who say that the question deals only with Mackay and Dick are reading the question of law in an unduly narrow way. Indeed, it is inherent or indeed implicit in the question of law that there are no obstacles, whether as a matter of law or a matter of construction, to a claim in debt. And if the Griffin is wrong, it does propose such an obstacle. So, my lords, that's my first point, taking it as swiftly as I can, given the time, that the question of law encapsulates the Griffin. My second point is that if it does not, or if there's any doubt about that, the question can be refined in a fairly unobjectionable way, which in my submission would put it beyond any doubt that the Griffin is within the scope of the question of law. And for that submission, I rely upon this Court's decision last year, which some of your lordships may recall from having been involved in it, in Sharp and Vatera. And that can be found on page 1065 of the bundles. For the benefit of those of your lordships who weren't involved in that decision, similarly to this case, it was an appeal under Section 69 of the Arbitration Act. The Court of Appeal had reformulated the question of law in that case to refer to the factual findings of the tribunal. And on appeal to this court, it was argued that the Court of Appeal should not so have reformulated the question. That was ground one of the appeal. My Lord Hamblin gave the judgment of the court and dealt with that issue between paragraphs 54 and 59. I think it suffices for me to show your lordships paragraphs 55 and 56. In paragraph 55, my Lord Hamblin stated that amendments to the question of law were permissible provided that the substance remains the same. And in paragraph 56, Lord Hamblin referred to and explained an example of his earlier decision in the Cotton X case, in which case the question of law had been reformulated from being an abstract question, a contract, to being a specific question, referring instead to the contract. And apropos the question of law in this case, I'm going to propose two alternative refinements to the question, both along the same lines. The first was actually proposed by Lord Justice Popplewell in the court below. his lordship suggested adding the words "in this case" to the end of the question of law, and so the final sentence of the question of law would read, "or must the claim be in damages in this case?" And in my submission, that addition is unobjectionable for the same reasons that the changes to the questions of law, the refinements to the questions of law in Sharp and Cottonex were unobjectionable, and that is that I didn't take your lordships to this part of the decision in Sharp, but in paragraph 57, my Lord Hamblin said that a change such as that is unobjectionable because it's implicit in every arbitration appeal under section 69 that what is being appealed is the contract in question. So that's my first alternative, or my first refinement that I would suggest. The second is to adopt the same approach which was taken by my Lord Hamblin in Cottonex, which was simply to refer to the contract instead of to a contract. And so with some further refinements for the purpose of making the question more readable, it would essentially read, where the obligation for payment of the deposits inserted thereto within the contracts was contingent upon the fulfilment by the buyers of a condition, and the buyers failed in breach of contract to fulfill that condition, is the condition deemed to be fulfilled with the result that the payment sum can be claimed by the sellers in debt, or must the claim be in damages? And in my submission, it's obvious that although the question was abstract, that is what the question meant. So, my Lord, I say either of those two refinements would be unobjectionable, based upon what my Lord Hamblin said in Sharp. But the real effect of those refinements is to shift the emphasis of the question. Instead of placing focus upon an abstract contract and an abstract issue, instead focus is placed on the specific contract, the MOAs, and seller's specific claim on those contracts. And in my submission, as soon as one is focusing more closely upon the particular contracts and seller's particular claim, circling back to the Griffin, whether the deposits are forfeit becomes obviously within the scope of the question, because it's seller's remedy depends in their claim, even if they have a potential claim in debt, upon whether the deposits were forfeit at all. So that's my second point, my lords. But even if there's any doubt about the question encapsulating the Griffin, it can be reformulated or refined in one of two very straightforward and unobjectionable ways. My third and final point concerns seller's objection that the Griffin was not a point before the arbitrators for determination, and therefore falls foul of one of the statutory requirements in section 69, that the issue was not before the arbitrators. Your lordships may also recall from the Sharp case that this was the second ground of appeal from the Court of Appeal. And in that case, what had happened in summary was the Court of Appeal had concluded that the sale contract, which was the subject of the appeal, had been varied. And on appeal to this court, it was said, well, that wasn't an issue before the arbitrators at all. And indeed, my Lord Hamblin concluded that the Court of Appeal had erred by reaching that conclusion and allowed the appeal. In the course of so concluding, in paragraph 62, my Lord set out the requirement imposed by section 69(3)(b), which is that the point has to be fairly and squarely before the arbitration tribunal for determination. That's the primary principle. In our written case, I won't take you to it for want of time, but we also set out two further decisions of the Commercial Court, Mr. Justice Cockerell's decision in the Ambar and Mr. Justice Pickens' decision in the Nyack and Crescent case, which add that it is sufficient for the point doesn't have to be spelled out as a question of law to the arbitrators. It's sufficient that the point was inherent in the issues for decision. In my submission, in this, as regards this case, there are two ways to analyse the issue regarding the Griffin, both of which lead to the conclusion that the issue was sufficiently before the arbitrators for the purpose of section 69. The first is to take a broad view of the issue and to say, well, the issue really, as I've said in relation to the question of law, is one of seller's remedy. So is there a remedy in damages? Is there a remedy in debt? In my submission, that was quite clearly an issue before the arbitrators. Taking a narrower view, the decision in the Griffin itself, in my submission, that too was before the arbitrators, because they necessarily applied the Court of Appeal's decision in the Griffin in order to reach the conclusion that the sellers had a remedy in debt. Now, what the sellers say, and I'm sure we'll hear my learned friends develop this tomorrow, is that in order to meet the requirements set out in Section 69, it was necessary for the buyers to tell the tribunal that they were going to challenge the decision in the Griffin. And in my submission, that is, it goes much further than the fairly and squarely before the arbitral tribunal for determination test, because it imposes, well, it cuts across the decision of Mrs. Justice Cockerell, which does not require it to be so explicit that a particular point of law is put to the arbitrators. As Mrs. Justice Cockerell said in the Ambar, it's sufficient that the issue was inherent. So, my lords, that's what I wanted to say about the buyer's alternative case. I have one short point in relation to the seller's alternative case on the Blankenstein. As your lordships may be aware from our written case, we do object to the sellers taking a point that the point that the Blankenstein was wrongly decided in this court. And I'm sure your lordships are familiar with the point, but essentially what the sellers say, as my learned friend Mr. Eaton set out this morning, is that the deposit accrued due when the MOA was agreed, and all of the conditions set out in Clause 2 were conditions to its payability. My short point about this is that the sellers took a very similar point before Mrs. Justice Dias at first instance. They lost on that point. That's paragraph 100 and 101 of her judgment and following. They applied to Mrs. Justice Dias for permission to appeal. Permission to appeal was rejected, and the point was therefore not taken and not dealt with in the court below. What now appears to be suggested by the sellers is that even though it wasn't dealt with below, and indeed could not have been dealt with below, they should be able to take it in this court by way of a respondent's notice, and they rely upon the Supreme Court rules, the now superseded Supreme Court rules, to say that there was no requirement for them to apply for permission to appeal. In my submission, that's wrong. It's wrong in principle, because the sellers should not be entitled to take a point which could not have been dealt with below, and indeed was...
But this is not an Arbitration Act point, is it? It's a rules point, is it?
Well, it's a rules point, but there is a point to be made about the Arbitration Act, my lord, which is that Section 69(8) of the Arbitration Act provides that, and this is the next point I was about to come on to, Section 69(8) of the Arbitration Act provides that Mrs. Justice Dias was the only judge who could provide permission to appeal from her decision which rejected the point. And that's the reason why the point wasn't taken in the Court of Appeal, because the sellers couldn't take it. So that's the second point. That's my second point, which is that because the sellers didn't obtain permission to appeal to the Court of Appeal, it wasn't dealt with in the Court of Appeal, so they shouldn't be allowed to take the point here. Now, one of the other points the sellers make is that the point they're actually taking in relation to the Blankenstein is a slight modification of the point they took before Mrs. Justice Dias relating to the Dominique, and the distinction relates to the condition precedent in Clause 2 regarding the MOAs being signed before the deposits accrue. In my submission, the effect of that distinction can only be to make my objection a fortiori. They didn't raise any argument about they didn't raise any argument based upon the...
Well, the courts below would have been bound by the Blankenstein, wouldn't they?
Yes, my lord, they would. Yes, but for the purposes of appeal to this court, the buyers didn't raise, or the sellers didn't raise any point about the Blankenstein in their original respondent's notice when they were responding to permission to appeal. They therefore didn't raise it before Mrs. Justice Dias at all, and for obvious reasons, it therefore wasn't dealt with in the Court of Appeal. My Lords, I'm conscious of eating into...
Anyway, it's a pure point of law.
Yes, it is, my Lord. Yes. My Lords, unless I can be of any further assistance, I'm going to sit down and let my learned friends take over.
Thank you very much, Mr. Barnett.
Thank you.
Yes, Mr. Kenny.
My Lords, I am going to address you on the rule, the principle in Mackay, and then on the Griffin. Mr. Hayne is going to deal with the Blankenstein. I'll start with Mackay, and I'll try to make 7 points, deal with 7 subjects. The first is the juridical basis of the principle. Is it a rule of construction, or is it a principle of law? The second is the Court of Appeal's decision. The third is assuming that the Court of Appeal were right to say that the principle is a principle of construction. What's the underlying principle? The fourth is, if they were wrong, it's a rule of law. What's the basis for that conclusion? The fifth heading of the key cases that we rely on, which we say are authority for the principle that the Court of Appeal identified. The sixth is the arguments that are made by the buyers on this appeal, by which they seek to distinguish the cases that we rely on, namely Hotham, Mackay, Panamina, Corey, and then finally the buyers' various arguments from principle. I'll start with juridical basis. As always seems amazing when you get to your Lordship's court, the juridical basis of this principle was not at the forefront of anyone's mind when we were in the arbitration. It wasn't really the focus of the debate. The focus of the debate was all to do with how various other provisions of the contract worked. When we went to see Mrs. Justice Dias, we said to her, well, either it's a principle of law or it's a rule of construction, but all roads lead to Rome. The result is the same either way. She has a passage in which, in her judgment, which I won't take you to, in which she says that the limited principle that she recognises is a rule of construction, but may also be supported by considerations of waiver. When we arrived in the Court of Appeal, we again took the same pragmatic, agnostic approach and said either it's a rule of construction or it's a rule of law, but the result is the same either way. I will therefore simply tell you where in the authorities you, like a tea leaf reader, can try and find some indications one way or the other. In our submission, Hotham and Panamina are both essentially neutral. The proposition that the principle is a rule of law has some support from Mr. Justice Devlin's judgment in Tebergen at page 1312 of the bundle. he says at the bottom of the first column that the buyer's failure to comply with the implied term by which they were to pay the customs duty made it impossible to effect delivery, and in those circumstances, under a well-known principle of law, of which the case of Mackay and Dick is perhaps the best-known example, the buyers are not permitted to assert that the sellers failed to discharge their obligation to deliver when it is they themselves who prevented the delivery taking place.
That was a recording of parties' submissions.
You're absolutely right, the submission is accepted over the page at 744. At the end of the first paragraph, accordingly, in my judgment, for the reasons which I've given and on the principle of Mackay and Dick, the defendants can't rely upon the defence that the goods were not actually delivered in London.
So what's that juridical basis?
That is
not
that is
permitted to assert. What's that?
Well, can I take that question in stages?
Yeah.
First of all, what is the juridical footing on which a preclusion might stand? And your first fork in the road is to say, this is a rule of law like estoppel. Lord Donaldson in Corey described the principle as a quasi-estoppel. And a preclusive effect may stand upon a rule of law like an estoppel. But even if it's
with no requirements of representation or anything like that. So what are the requirements of this estoppel then?
If it were a rule of law, it would be a preclusion that arises from the same elements that justify, in the Court of Appeal's view, the construction of a contract as not permitting the party to take advantage of his own breach, namely that the party who is going to be precluded is breaching his contract, that the effect of his breach is to prevent the satisfaction of a condition to his obligation, so that absent the preclusive effect of the estoppel or quasi-estoppel, the other party would be unable to assert or claim the relevant obligation.
What is meant by quasi-estoppel?
There is no discussion of what the quasi was intended to add to estoppel in the judgment. If it were important, I would suggest that what His Lordship is suggesting is that this is a form of preclusive rule out with the convention or the more commonly recognised estoppels of estoppel in pace or estoppel by representation.
So it would be outside the normal
outside the normal ambit of
or a sui generis preclusive rule.
That's what I wish I had said. First question is
sorry. The way in which the submission was made to Mr. Justice Devlin on page 1312 would include all breaches, wouldn't it? The Cully type situation. That is a
and my lord, you're right, and that is why in our written case we have said, to be clear, we don't rely on the result in T-Bergen, but on the dictum recognising Mackay and Dick as a well-known principle of English law. But you're right, it doesn't, the decision in T-Bergen does not confront the Colley exception and doesn't address it. So,
and what was the nature of the argument? Well, sorry.
Yep.
I'm taking out your way. What was the response by the other side to this argument being put forward? I mean, did they
we see
say...
the right-hand column of
Yes,
1312.
Yes, sorry. Yeah.
Yeah, and the claim by the sellers succeeds on the basis that it's not open to the buyers to defeat a claim for the price by asserting that the goods were not released from customs owing to the buyer's failure to perform their duty to release the goods from customs. But let me not get too far dragged into this, because at the moment, all I'm trying to say is when we look at the cases, there are a scatter of points, some of which are consistent with concluding that the principle in Mackay is a rule of law, others of which are consistent with the view that it's a rule of construction. I started with T-Bergen. Corey, we've already mentioned that.
But how do you say it's expressed in Mackay and Dick itself?
In Mackay and Dick, in both judgments, it is either neutral, in as much as there's no examination of the basis, or it's a principle of law.
Well, Lord Watson.
It wouldn't be one of the cases that you would rely on to say it's a rule of construction.
I mean, Lord Watson treats it as a principle of law derived from civilian sources, a principle of deemed fulfillment. Lord Blackburn seems to say two things. One is an implied term that both parties will cooperate to secure the fulfillment of contractual conditions.
Yes.
And the other point he makes is to categorize this as a condition subsequent to the delivery of the goods, a condition which, if fulfilled, would absolve the purchaser of the obligation to pay for them, but which could not be fulfilled and therefore fell out of the picture.
My Lord, this is such an interesting point. I'm going to address it now, although I'm going to come back to Mackay and Dick. But essentially our submission is that the two judges in Mackay and Dick are in fact both applying the Mackay principle and deeming in the one case a test to have been done and the test to have been successful, and in the other deeming the buyer to have dispensed with the need for a test. The starting point for analysing both judgments is the Court of Session's interlocutor, and in particular the second finding in the interlocutor, and that is, I think, 743.
So of the two deemings, you say Lord Blackburn is the first and Lord Watson the second, is that right?
So Watson deems there to have been a successful test.
Oh, okay. Yeah.
And sorry, did I say Watson? Yeah. So Lord Watson deems there to have been a successful test.
Yeah.
And Lord Blackburn deems the test to have been dispensed with, Lord Justice Ricks, in his analysis of this case, says what he says suggests a deemed waiver. Essentially, Lord Blackburn's view is that what the buyers have in effect done, or must be taken to have done, is say to the sellers, don't bother with the test, I'm just going to keep the machine. But either way, on the face of the contract, let's just look at the interlocutor second finding. It's page 749 of our bundle. So this is the findings of the court below with which the House of Lords could not interfere. Second, find that it was a condition of the said contract that the defender should not be bound to accept and pay for the said machine if it should fall short of digging and filling 350 cubic yards within a day at a certain railway cutting coffin. So that, whatever the position may have been, and we know that Mr. Justice McCarty in Colley says under Scottish law there's a transfer of property ahead of the test. But whatever the position may have been, the contract by its terms says you don't have to pay until this test has been carried out. And the way in which Watson...
Well, it doesn't quite say that. It's put in a negative way. The defender is not bound to accept or pay for the machine if it falls short of, if it fails the test. Now, of course, it never did fail the test.
No. But
so that's your home in one bound.
But when did the, well, when a tribunal says that to me, I want to say yes. But when did the obligation to pay arise on this? I mean, it couldn't be that the seller could say to the buyer, well, I've delivered it to you now. Admittedly, we're months away from doing a test, but I want to be paid. The obligation to pay implicitly arises after the test has been carried out. And therefore, the conduct of a test is a precondition to the obligation to pay on the face of things. Now, there might be two ways in which the conduct of the test is not required. One is, as Lord Watson says, because the test has been thwarted, and in those circumstances, the test must be taken to have been successfully carried out. The other is, if the test is thwarted, and in those circumstances, the buyer must be taken to have said, well, don't bother with the test. I'll just take it anyway.
Well, the way Lord Blackburn deals with it on 755 is, what about two-thirds of the way down the page? He says, if they, that's the courts below, find the facts truly, into which your lordships have no right to inquire, it would follow in point of law that the defender, having had the machine delivered to him, was by his contract to keep it unless, on a fair test, according to the contract, it failed to do the stipulated quantity of work, in which case he would be entitled to call on the pursuers to remove it. And by his own default, he can now never be in a position to call upon the pursuers to take back the machine on the ground that the test has not been satisfied. He must, as far as regards that, keep and consequently pay for it. So it was a fact that it was a condition. It was a condition subsequent, rather than a condition precedent, which was important to Lord Blackburn's reasoning, or not in that passage anyway.
and perhaps one, the difficulty with the language of condition subsequent is it might imply that prior to the fulfillment or not of the condition, there was an existing obligation to pay.
Well, it was defeasible. It was keep and pay unless. And the unless could never happen because of the defender's conduct.
But the moment at which payment actually had to be made, the time at which payment had to be made, was at the due time, after the due time for a test. It wasn't an obligation to pay as soon as delivery was made. So you're right to say it was defeasible as a future obligation, but the buyer was only going to have to pay if the due time for a test had arrived, and either the test was successful, or at the due time, he thwarted the test, and by thwarting the test, depending, pick your judge, pick your result, by thwarting the test at the due time, either the test is deemed to be successful, or he is deemed to have dispensed with the test.
There's no language of waiver at all in Lord Blackburn's. I appreciate that Professor English analyses Mackay against Dick on this basis, Lord Blackburn's judgment on this basis. Yeah, but there's absolutely there's no language of waiver at all.
And indeed, just while we line up our rogues gallery of people who view this as a waiver, also Lord Justice Ricks. Yeah. He says perhaps Blackburn's judgment feels like waiver. The answer is the insight that both English and Ricks have is that by his own default, he cannot be in a position to call. What has he done by his default? His default was to thwart the test. And when you thwart the test, what are you taken to have said to your counterparty? Well, you may be taken to have said, don't bother with this test. I don't care what the test says. And in that circumstance, as Lord Reader suggested, given the way in which the clause is drafted, absent an exonerative test, liability for the price accrued due. It's a very nice distinction between the premise of the two judges' views and then the way in which they see the thwarting operating. I accept that Blackburn sees the test as, Lord Reedy's expression, a condition defeasant, but perhaps an exonerative test, a test that would prove that or confer a right to reject, whereas Lord Watson sees it as a validating test, a test that confers a right to claim the price on the seller. But either way, there was to be a test as a prelude to any payment or rejection, and either way, the thwarting of the test had the effect of deeming the validating test to have been successful or deeming the exonerative test to have been dispensed with.
So is your main point that people have tended to look back at Mackay and Dick as only Lord Watson using a deeming analysis?
Precisely.
Because they've concentrated simply on page 754, whereas if you read on in Blackburn, you're saying that he also adopts a very similar approach.
Although he starts from the premise that finding number 2 in the interlocutor provides for an exonerative test, and absent the conducting of the test at the due time for the test, the price falls due. he, like Watson, regards the thwarting of the test as essential to the case.
And he also finds the price is due.
And he finds the price is due upon the default by the buyer, which means that he can never set up an exonerative test as a reason for not paying. At that point, the price falls due. All right.
It's interesting that the authority that Lord Blackburn relied on, the old case of Mildenhall from 1469,
yes,
page 754, is also about a defeasible obligation.
It is, but my lord, don't fall into the trap of thinking that that reasoning or that case was being raised or relied upon in relation to the condition. What the men of Mildenhall is doing in his reasoning is supporting the conclusion that he's come to just before there, where he says that it's an implied term that each party's got to do their bit. Yes. So I've got to do my bit, you've got to do your bit. This is illustrated by Mildenhall, where the men of Mildenhall brought the bell to the brazier, or to the bell maker, but it was the bell maker's job to weigh it and put it in. So all it's doing is illustrating the very simple point that it's actually adding a little bit of putting flesh on the bones of the famous Mackay-Dick principle, which is we've got to cooperate with each other, by saying what cooperation entails is that I do my bit and you do yours. All right, so I said that there were some very small indications each way as to whether various judges had thought that the principle in Mackay and Dick was a principle of law or a principle of construction. I showed you Devlin and Tebergen, which might suggest that it's a principle of law. Lord Donaldson in Corey, we didn't turn up, but Lord Hodge recalled that it was quasi-estoppel.
That's where the phrase appears in Lord Donaldson's judgment.
Exactly. We then have Lord Justice Ricks in Noga, page 842 of the bundle, para 106. And I'll just let you remind yourselves of what para 106 says. He calls it a well-founded and general principle of English law. And then finally, there's Professor English, whose article we've already come across today. He says at page 1716 of the bundle that it's a pity that the Court of Appeal said it was a rule of construction because it's better viewed as a rule of law. On the other side of the fence...
This is we said yes, we saw it earlier, yes.
Yeah, we saw it a little earlier. On the other side of the fence, there's Mr. Justice Scott's judgment in Thompson and Asda at 1306 of the bundle. Where he says the principle expressed by, this is at F.
Page, please.
1306.
Thank you.
He says the principle expressed by Lord Watson and Mackay and Dick is not, in my view, a principle of English law. The fictional fulfilment of conditions precedent and the fictional non-fulfilment of conditions subsequent may be principles of civil law, but they're not principles of English law. In this area of the law of contract, English law proceeds, in my view, by means of implied terms. Now,
that's the little encourage approach.
That's the little encourage approach. Yeah. And I will say in a second, as I comment on what the Court of Appeal have said, that there is perhaps a nice distinction to be drawn between conclusions of construction and conclusions founded on implied terms. But I don't press that distinction. It seems in our submission that the right approach to look at this is to look at what the contractual effect of the instrument is. Whether you articulate that in terms of construction simpliciter, or whether you articulate that in terms of an implied term, but the contractual construction approach is founded upon giving effect to what the instrument means on its proper construction, given the appropriate canons of construction.
I didn't understand you to be advancing a case based upon implied terms, but perhaps I've misunderstood it.
Well, we have always said that the Court of Appeal's decision is construing Clause 2 and identifying what Clause 2 on its proper construction means, and in short, what it means is that the deposit will be paid when the stakeholder has said that the account is open, or in the event that the buyer thwarts the opening of the account, when he would have said that.
But that must be an implied term.
Well, that is what Clause 2 means on its true construction.
But does it say that? But aren't you having to read words into Clause 2 to achieve that result?
Well, yes, but
then you're into implied terms.
It is often said by, I mean, of course you're right to say that that is not the literalist or literal sense of the words of Clause 2, and perhaps you have to, perhaps you will conclude that you have to imply words, but the approach of the law in this field has been to treat the interpretation of a clause so as to give effect to what we're going to we're going to look at it in a minute, which is Lewison's 10th canon: a contract is always construed as far as possible so that a party can't take advantage of it, of his own wrong, in terms of construction, rather than suggesting that implication of words is necessary. So the answer is the rule of construction that the Court of Appeal proposed is our first submission, just that, and it's a way you then have to. Lord Justice Mayle said to me in a case where I said, "Oh, they're involved in implying words." He said, "Well, they're not implying words. They're just saying what the instrument means, and how it would be understood by a party conscious of the relevant principles of interpretation." And in this case, our primary position is you just construe it and give effect to how the instrument would be understood to operate by a party who has in mind the relevant canons of construction. If you say against me, I'm sorry, I can't deal with this except by implying words by way of a qualification, then I say fine.
Well, if that's the case, what are the words?
The words would be unless. So let's just open clause 2 and look at.
I'm concerned to see this as a matter of construction. The Privy Council judgment in Belize treated the implication of terms as just a factor of construction, but this court in Marks and Spencer made it clear that there were separate exercises to be carried out. But I suppose you can pray and aid the officious bystander, saying, well, it's obvious how this had to work, even if the words weren't there on the page.
I mean, it's really how in the way in which adopting the way that Lord Justice Millett had expressed it in Little and Courage, it's a question of construction, how the clause would apply in particular circumstances, and in particular whether the condition has to be complied with.
Yes, but Lord Millett in Courage was writing well before Marks and Spencer.
I think what you're saying, as I understand it, is people have used the broad term construction.
Yes.
Other people have used it, and I think this court has made quite clear there are two separate exercises. One is construction or interpretation of what's there. The other is putting in what's not there. I think you're saying, although you've focused on the first of those, you're not precluding our going into the second of those, i.e. implication of terms, if we're not satisfied.
Precisely.
If we can actually do it on the first.
Having proper regard to the limits of the construction exercise as guided by Marks and Spencer, you take the view that the only way of reading this instrument as having the effect that the Court of Appeal said that it had is to imply words.
Okay, but so what are the words?
Okay, so the words are, let's just get the MOA. Clause 2, so that's 180. The purchase, the seller shall lodge a deposit of 10% with the deposit holder within 3 banking days after the date that, 1, this agreement has been signed by the parties in exchange, and 2, the deposit holder has confirmed that the account is open and ready, or if the buyers wrongfully fail to supply the relevant documents.
Hang on.
One second.
Or if the buyers
wrongfully fail to supply the necessary documents, is actually the expression used in line 42.
Yes.
Within 3 days after the date on which the deposit holder would have confirmed the account was open.
Sorry, 3 days of the date.
On which the deposit holder would have confirmed the account was open if the buyers had done what they ought to have done.
And what do they do? Sorry. They pay to who? So the implied term is?
It falls due either when the account is open or when the deposit would have been payable to the account. And well, let me just repeat exactly, because if you're writing down, let me just get it absolutely right. If the buyers wrongfully fail to supply the relevant documents within 3 days after the date on which the deposit holder would have confirmed the account was open if the buyers had done what they ought to have done.
But the first sentence, or the first line of clause 2 is, shall lodge a deposit with the deposit holder. And
Yeah.
how does the deposit holder get hold of it?
It is not possible, obviously, for them to comply with their duty to lodge. They come under a duty, the debt, they are under a contractual obligation.
All I wanted to find, I'm sorry for interrupting, all I wanted to find out was the implied term, to whom should the deposit be paid under your implied term?
To the deposit holder.
Which is defined on the previous fee.
Which is, so, I apologise, it's Holman, Fenwick and Willan. It's Holman, Fenwick and Willan in Greece.
Yes.
Sorry, my lord, the question I thought you were putting to me was, if the account isn't open, how do they pay? And the answer is, well, they can't pay because they have made it impossible to them to perform. But that's just like the case where I agree to sell you a painting and then I sell it to someone else and then I can't do it, but I'm in breach. And the consequence of that is that, of course, until they've remedied the position, they can't perform their contract. But in the meanwhile, the debt is due. We have the right to terminate under Clause 13 for failure to pay. And if we're right on the Griffin, we're able, if we do terminate, to then sue them for the deposit that they failed to pay.
You know, I think it's possible that this could be absolutely critical to the appeal. You might want to take time to consider exactly what wording you're putting forward, and let us have that perhaps tomorrow morning.
Well, I will think about it overnight, but since I had given...
On your existing term, you also reflect on when it ought to have been done.
Yeah, so my lord, when I say I'll of course accept that invitation, I don't want to give you the impression I hadn't thought jolly carefully about it before.
No, I don't want to give you the impression that I'm implying that you haven't. But this is a much more complex implication than the one that Lord Justice Millett was concerned with in the Courage case. And judges tend to get nervous the more and more complicated the terms are that you're trying to imply into a contract, and people will start picking holes in it.
No, let me just. I mean, it's designed. It's drafted in a way that is designed to make clear to you the gist of the effect of what we say the implication is, but let me just make clear the way in which it operates. The bank account is going to be opened by Holman, Fenwick and Willan. In order to open the bank account, they need documents from both parties. The documents consist of KYC documents, know your client documents, passports, and signed agreements to hold an account via Holman, Fenwick and Willan. If, as happened in this case, the buyers either fail to supply copies of their passport or fail to sign the necessary documents, Holman, Fenwick and Willan can't open the account.
They can't open the account for the parties. They can open their own account if they wanted to.
Yes, but the scheme of the contract is that they will open an account in the joint names of the parties or on behalf of the parties.
In escrow.
In escrow.
And so if the parties... So if the deposit holder... I'm not suggesting for one moment they would do, but if the deposit holder went into bankruptcy, that would be his own money in his own account, and you would have a bit of a squabble over it, as opposed to a joint account held by the parties.
I have many years of expertise on these transactions
Yes.
sitting behind me, so that's
Yeah.
something I really will ask overnight. But
Yeah.
as I understand it, the account is going to be a trust account in the names of the parties, and therefore, in the event of the insolvency of a stakeholder, wouldn't fall into the estate of the stakeholder, but would be identifiable trust assets held on behalf of the parties.
And so what happens if there is no trust account and the account is just the account of the deposit holder?
Well, the answer is Holman's wouldn't accept a payment to their own account. It would only accept a payment of the deposit to the trust account that they're going to set up. And that's why I say that's why I make this.
I'm slightly at a loss because it appears that in order to set up the trust account, you need to have know your client's information.
Yes.
And absent that, they can't set up the trust account.
No, precisely.
And absent that, there's no account into which to lodge the money.
Precisely. No, I accept that.
And where do you lodge it then? If you
the answer is they are then unable to perform their obligation. But the reason they are unable to perform their obligation is because they've made it impossible.
Where does the money go to now?
Well, the answer is they are necessarily in breach until they have remedied the position by providing the documents and allowing, therefore, Holman, Fenwick and Willan to open the account.
If they can't open the account, under the implied term that you're suggesting, into what account is the money to be paid?
The sellers must, the buyers must perform their contract.
You can't get specific performance of that obligation.
No, I'm not suggesting specific performance. But what the contract requires is that the buyers supply Holman's with the documents that they were going to provide. Holman's then open the account. Holman's will then notify the parties the account's now ready to use. Now, assume that's taken 5 days beyond the deadline. At that point, if we haven't cancelled, the account is ready for use and the money can be paid into the account. If in the meanwhile, perhaps on day 3 after the buyers are in default, we have cancelled, it's just the position that they, by their prior breach, have made it impossible for themselves to perform the contract. There's no. You're perfectly right to say that if they don't provide KYC documents to Holman's, don't ever provide, they will never have an account into which they can pay, and therefore it will be impossible for them to perform their obligation to pay the deposit. They are in a position to disable the performance of this contract by refusing to provide the necessary wherewithal for the contract to be opened, but that's just a consequence.
With so much I understand, but you were drafting, and I also would very much welcome a written copy of the implied term, but you proposing an implied term, and I was just inquiring, under that implied term, into what account is the deposit to be paid? Into
the trust account that will be opened when they comply with their obligations.
But that's going round in circles.
Well, my Lord, I totally understand if you say, but under this implied term imposes an obligation on them, or has the result that they come under an obligation to make a payment that they are, in practice, unable to make. That is just a totally workaday consequence of their earlier breach in failing to supply documents. Just imagine that the Clause 2 had said, you, the buyers, will supply all necessary documents, and in all events will make a payment by the 1st of June. All right? They don't supply documents. 1st of June comes and goes. We would say, on the 1st of June, on the 2nd of June, on the 3rd of June, you're in breach of your obligation to make a payment.
They don't deny that. They don't deny breach of contract.
They don't deny, no, you're right, they don't deny, and indeed they've never taken the point that I think, my lord, you are putting to me, but what they say is, I was in breach of my obligation to supply documents, and as a result of not supplying documents, my obligation to pay the deposit never arose.
Yes, that's what they're saying.
We say you didn't supply documents. You by not supplying documents, prevented the fulfillment of the satisfaction of the condition, and you came under an obligation to pay the deposit.
To pay to who? I mean, your claim is you're entitled to be paid directly, isn't it? So how do you get there?
Why isn't the implied term, or if the buyer wrongfully fails to supply the necessary documents within 3 days after, the buyer should pay the deposit of 10% direct to the seller?
My lord, that is another way to, and indeed that's what Mr. Chu suggests.
It has to be that, because otherwise, on what basis is there a contractual obligation which you're seeking to enforce to pay the deposit to the seller?
Because there are two stages to this, and the first stage is the deposit becomes due. We would say, subject to my Lord Burroughs' alternative, but we would say it became due to HFW in the account that had not yet been set up. When we cancel under Clause 13 or accept their repudiatory breach, we then say to them, we're forfeiting your unpaid deposit. Your unpaid deposit was owed to HFW, you never paid it, we are now forfeiting that, and at the moment that we forfeit it, it becomes due and payable to us. A forfeited deposit is payable to the counterparty. So at the point that we say, now we're, all bets are off, we're cancelling this contract, we will say to the buyers, okay, forget about paying to Holman's, the contract's terminated, we forfeited the deposit, you can pay us.
That's dependent upon you terminating the contract. Is that right?
Our right to forfeit is dependent on us terminating the contract.
Right.
When we terminate, we get fed up and we say, okay, we're not continuing this any longer. At that point, we say, you haven't paid the deposit has become, but because of the termination, the deposit has become forfeitable, we forfeit it, and now you can pay us directly. And my bank details are this.
And this is all at law, something in the contract that deals with this?
It is on the true construction, the way in which, this is the subject matter of the Griffin, and perhaps it would be helpful just to look at the Griffin. So,
from what you've just said, it sounds as though you're not actually implying the term. You're saying there is what we can all see in Clause 2, a contractual obligation to pay the deposit to the solicitors to be held on escrow. And you seem to be saying that if there is a failure to fulfill that obligation, the seller is then entitled to terminate the contract, declare that the deposit has been forfeited, and there is then a secondary obligation that comes into being on the part of a buyer to pay the forfeited deposit to the seller.
Precisely.
Is that it?
Precisely.
Is that consistent with the first paragraph of clause 13, which specifies the right as being a right to claim compensation for losses and expenses if the deposit isn't paid?
My Lord, the point you've just raised is the subject matter of the Griffin and is the argument that Mr. Eaton makes on his Griffin appeal.
Yes.
All right. So, I mean, maybe it'd be helpful just to look at, but just before we do, my Lord, you say there is an obligation to pay the solicitors until the contract is terminated. Then we forfeit the unpaid deposit and we say, pay us directly. That's all absolutely right. But what the critical question is when does the buyer come under an obligation to pay the solicitors? Their case is, I didn't come under an obligation to pay the solicitors until the solicitors said the account's ready. And we say, you're precluded from relying on the non-satisfaction of the confirmation the account is open because of your thwarting of the solicitors opening the account. Now, as we've said in the written argument, that there are lots of different ways of expressing the way in which the Mackay principle operates. And the way in which the Court of Appeal expressed it, and we've touched on already deemed satisfaction, deemed waiver, but the way in which the Court of Appeal expressed it in paragraph 79 to 80 of their judgment, sorry, it's 85. I would therefore formulate the principle as being that an obligor is not permitted to rely on the non-fulfillment of a condition precedent to its debt obligation where it has caused such non-fulfillment by its own breach of contract, and then subject to the provisos and caveats that have been the subject of complaint and argument.
So your approach is to imply a term into clause 2 so that there will be an obligation on the part of the buyers to lodge the deposit with the deposit holder, even if they have failed to provide, even if they have failed to comply with their obligation in the last sentence to provide the necessary documentation.
Precisely.
And you then have that implied term so that they will be in breach of clause 2 if they fail to lodge a deposit in accordance with that implied term. And
exactly.
It's then that default which then entitles the sellers to cancel the agreement and forfeit the deposit. And you then have the issue about the effect of clause 13 that Lord Hodge has raised.
Precisely.
But on that formulation, the obligation to lodge is with Holman and Fenwick, is it?
Yes.
But even though they can't open the account if documents aren't provided.
That's why we say that is just the consequence. That's the pickle that the buyers have put themselves into by disabling themselves from performance. But it's just a classic example of my
You're
breach
implying a
disabling.
term that they're obliged to do something which can't be done.
But with the result that they are in default, with the result that we then have our remedies in clause 13. In particular, what we can do is we say, right, you're now liable to pay. You can't rely on you. We will say, look, you've failed to pay. They say, oh, but we haven't had confirmation yet. We say, no, you're precluded from relying on the absence of confirmation by the fact that you brought that about, so you are in breach. And then, as Lord Reid says, we are able to say, okay, so now you've failed to pay the deposit on time, so now we're going to treat you as being in default, we're going to terminate, and we forfeit, and now instead of paying to the account that is not open because you caused it not to be open, you can just pay it to us.
Well, I think you might need to address us on the issue of implying a term which is impossible of fulfilment. It's an unusual thing for a court to do.
Well,
I may be missing something here, but you're entitled anyway to terminate the contract for repudiatory breach by failure to lodge by failure to hand over the documents. They're already in there's already repudiatory breach by the other side.
When does that breach become repudiatory? That's the difficult question.
Immediately. Why shouldn't it be?
Well, what if they say, oh, we're looking for our passport, we can't find it. Of course we want to carry on with this contract.
But it's not what they said. They said we're not paying it. We're not providing the documents. Isn't that just plain repudiatory breach?
Right. Of course you're right that if there's a clear renunciation, I'm not performing this contract. You just forget it. But Lord Burroughs' analysis has to be tested in terms of saying, is any failure to supply documents without delay, without more repudiatory? Well, we might make that submission, but it's not self-evident that that's the case.
I thought it was taken as read that the failure to provide the documents by the buyers was a repudiatory breach.
We have certainly argued that they were both in repudiatory breach and by reason of continuing failure to supply documents. But the I think I better consider where that.
But what I'm saying is, I mean, okay, I said immediately, but whenever it becomes clear that they aren't going to provide the documents.
Okay, at that point, that's conduct evidencing renunciation.
Yeah.
So at the point where we say, hang on, 5 days have gone by, you still haven't provided your documents, they say, that's because we're not going to. Okay, that's renunciation. But assume it's just, we say, 2 days have gone by, have you submitted your documents? Oh, no, we're a bit busy at the moment, we're going to do it very soon. Is any failure to supply documents?
Well, this is a familiar problem. I mean, there are quite often situations where a delay might not amount to a repudiatory breach on day one, but there comes a point in time where it does, and it's a matter of judgment and the circumstances whether you reach that point.
But I thought that they made that case pretty clearly. We're not providing these documents. Full stop.
Yeah, and I accept that if they, where those are the facts, and a party says, I'm not providing the full stop, it's renounced, and you're entitled to say, well, this contract is, I have a common law right to accept that renunciation and bring this contract to an end.
Well, let's say nothing said or done about documents. They simply say, we're not going to perform.
Yeah.
Clear renunciation, and you accept it. What would your claim be for? I mean, would you have a claim in debt in those circumstances? If so, how?
When do they say that? If they say, we've just signed the contract, and they say, you know what, actually we've changed our mind, we're not going to perform, Our second string appeal, Mr. Haynes' argument, is that the
leaving aside the
deposit accrues on it as a the Court of Appeal were wrong to say that the obligation, the debt. We essentially adopt Stevens and Chu in saying...
No, but leaving aside that argument...
Okay, so leaving aside that argument, the debt falls due, the debt, which is the obligation to pay money to Holman, Fenwick and Willan, falls due when the two limbs of Clause 2 are satisfied. So
any accepted repudiation before then would mean no claim in debt.
Exactly. Okay. I mean, there's a very refined postscript to that, which is when is the value of the deposit recoverable as damages?
Well, nobody's arguing
in the
that.
Blankenstein, do you remember that?
Yes, but nobody's arguing that here, as I understand.
But no one's argued that on this appeal.
No.
I mean, it's going to get argued when it goes back. Okay. But no one's arguing that on this appeal. So the answer is, leaving aside that refined postscript in the Blankenstein, if before the deposit had fallen due, we had just accepted their repudiation, then we're just looking at straightforward damages, and the golden victory point is being levelled out.
Subject to my Lord Reid, I would very much welcome a written summary of the case you're making about an implied term and how it then rolls on into the right to repudiate. And I think that, in fairness, the other side should get that in sufficient time to properly analyse it, because it's not part of the written case.
Well, my Lord, the answer is to that although I appreciate that your Lordships have focused on the effect of construing the MOA in the way that the Court of Appeal have suggested, and your Lordships have indicated that perhaps that you think that this is a construction that requires some implication, and then you've looked at the ramifications of the implication. The Court of Appeal didn't have any difficulty with this. They said, on the facts of this case, it's clear that once you conclude that on the true construction of Clause 2, in circumstances where they had thwarted the opening of the account, that they were in breach of their obligation to pay the deposit, you were entitled to terminate and forfeit. And they regarded that, first of all, as not requiring an implied term, but a conclusion that they could come to on the basis of the construction of the words used, and not entailing the kind of practical difficulties that I can see your Lordship is perhaps troubled by.
I think you were going to tell us which authorities supported a rule of construction.
Yeah, let me get onto that. The answer is we looked at Thompson. We've looked already at Little.
I don't know if we did look at Thompson. You took us to page 1306. Did we go actually look at anything that was said there?
Right.
You took us to Mr. Justice Scott and his statement that Lord Watson's principle wasn't part of English.
Yeah, my Lord, I think we did look at the
I'm
last
sorry.
paragraph.
No, that's my fault then. Oh, yes, if a suitable term can be implied. Yes, and that took us into the, the question of the implied term.
All right. Then two other authorities standing on the construction side of the divide. One is Newmont, which is a decision of the Privy Council, which is at starts at 793 and the relevant passage is at 801. I just invite you to read the first 12 lines of that paragraph. And then, finally, Alcasane, which is not an application of the principle in Mackay, but is an analogous case in which an agreement was construed. In that case, but perhaps it predated Marks and Spencer's, without the suggestion that any words had to be implied, as having the effect that the party in default couldn't take advantage of the requirement to grant a long lease for which the contract provided.
Which case is it?
So that's Alcasane,
right?
And it's in
246.
246.
So this is can't take advantage of your own wrong.
Exactly.
As a principle of interpretation.
And just so that just to remind you of the facts of this, it's an agreement between a landowner, Eton College, and a developer, Alcasane, under which the developer agrees that it will build a block of flats. And then clause 4, which you find at the bottom of 248, says, upon the proper issue of the certificate of practical completion, the landlords will forthwith grant the tenant, and the tenant shall forthwith accept and execute a counterparty of the lease. So that's going to be a long lease as soon as the building's built. Provided that, if for any reason due to the willful default of the tenant, so due to Alcasane, the development shall remain uncompleted by 29th September 1983, the lease shall forthwith be granted and completed as aforesaid, and then without prejudice to the earlier provisions. And Alcasane, that's in dispute, but assumed for the purposes of the claim, Alcasane says, well, we're in willful default, now grant us the lease. And the college said, on the true construction of this instrument, although it says, appears to say that if for any reason to use the willful default of the tenant, the development shall remain uncompleted, the lease shall forth be granted, we're not obliged to give you a lease. And the House of Lords accept the college's case and says that this must be construed, and the relevant passage is essentially Lord Jauncey, with whom the rest of the House agree, tells you what the Court of Appeal decided at 250D. In the Court of Appeal, Lord Justice Dillon, with whom Wolfe and Fox agreed, concluded in the light of the authority cited that as a matter of construction, the proviso to Clause 4 had to be read subject to the implied condition that the party seeking to found on the proviso was not himself in default. So that essentially finds that on the true construction of Clause 4, it wasn't open to Al-Hussein to found on the proviso and demand a long lease. In considering whether that was right, Lord Jauncey, I take you first, if I may, to page 252, where Lord Jauncey...
On 251 is interesting. Lord Justice Scrutton is quoted in the middle of the page, putting this principle on the basis of estoppel.
Well, I mean, that, my lord, of course that's right, but he's also dealing with this construction. He's riding both horses, isn't he? Because he says, well, Clause 12 and all the other clauses be read subject to an overriding conditional proviso. Now that looks as though he's construing it, and in construing it is reading in a proviso. And the effect of the proviso is the estoppel. And that goes back to the question that Lord Hamblin put to me, where he said, well, when you say preclusion, is that consistent with rule of law or rule of construction? I said, well, it could be either. It could be the effect of the construction that you give the clause, that a party is precluded from relying on some part of the clause. And that actually is exactly the way in which the Court of Appeal put their construction. They said the effect of the rule is that on the true construction of the relevant of Clause 2, the buyers are precluded from relying on the fact that the stakeholder have not declared the account ready for use. Anyway, I was taking you to a famous passage from Lord Diplock's judgment in Cheel, and actually this is going to...
I'm sorry, I see the time, but I interrupted you and you were just going to take us to 252.
Yeah, 252, and that's what I'm...
That's Cheel.
That's Cheel. Ah. So it's at 252 at G, and I just so you're not panicking, I'll just take you through the relevant passage in this decision and then close for the night. But at 252 in G, finally in Cheel, Lord Diplock, referring to the New Zealand shipping case, said at page 188 to 189, in the course of the speeches, which are not entirely consistent with one another, reference was made by all their lordships to the well-known rule of construction that except in the unlikely case that the contract contains clear express provisions to the contrary, it is to be presumed that it was not the intention of the parties that either party should be entitled to rely upon their own breaches of his primary obligations as bringing the contract to an end, i.e. as terminating any further primary obligations on his part then remaining unperformed. And essentially Lord Jauncey takes that test, and my Lord Burroughs, you asked, where does one encounter in the law the concept of presumed intention? I think we may have emailed to you a passage, another passage from Lewison, which is about canons of construction, which says canons of construction operate by telling you what the presumed intention of the parties is, and that I think is chapter 4 of...
Yes, we've got that.
You've got it.
Yeah.
You know, we have hard copies for you if you'd like those.
I mean, Lewison sets all this principle out, doesn't he? I think you've given us the extracts in the main bundle at 1597.
We have, exactly. So he sets that out, and then just to finish, because this is putting this in context. One of the players on the side of it's all a rule of construction, Lord Jauncey then adapts Lord Diplock's dictum in Cheel, and you see him adapting that at 595D. Sorry, 254 of the bundle. So 595 of the internal paging. And he says, there remains the question whether, in the words of Lord Diplock in the Cheel case, the agreement contains clear express provisions to contradict the presumption that it was not the intention of parties that either should be entitled to rely on his own breach to obtain a benefit. I find no such clear express provision. Although the proviso refers specifically to willful default of the tenant, it doesn't state that the tenant should be entitled to take advantage thereof. It's one thing for the willful default of the party to be made the occasion upon which a provision comes into operation. It's quite another for that party to be given the right to rely upon the default. And then he ends, and this is why we say this supports the view that the relevant principles are rules of construction. He ends at F by saying, it only remains to refer to the respondents.
Yes, yes.
Sorry. All in all, the terms of the proviso were not...
Yeah, I think you were right where you were. It's G. For my part, I have no doubt the weight of authority favours the view of the general principles embodied in a rule of construction rather than in an absolute rule of law.
Exactly.
Well, thank you very much. I think that's probably enough for one afternoon. We'll resume at 10:30 tomorrow morning.